Welcome to the Deep Dive, your shortcut to being truly well-informed without getting lost in all that information overload. Today, we're taking a really deep dive into a powerful legal document, one that profoundly shapes daily life in the Philippines. It's Republic Act No. 9211, also known, maybe more famously, as the Tobacco Regulation Act of 2003. Now, this act isn't just about simple prohibitions, not at all. It's built on what's called a balanced policy. And that's where things get really interesting for us today, I think. How does a government effectively protect its citizens' health from something hazardous like tobacco, while at the same time safeguarding the economic interests of a major industry and, the livelihoods of thousands of its workers? That's the tightrope this legislation walks, and that's what we're going to unpack.
It is an incredibly complex challenge. It really requires a multifaceted approach. You've got public health on one side, absolutely critical. But then there are these significant economic realities for a huge number of people. So our mission in this deep dive is to explore the full scope of this legislation, from those public health mandates to the equally important economic considerations, and really understand how it impacts people on the ground.
Okay, let's dive right in then. The full title is quite a mouthful, isn't it? An act regulating the packaging, use, sale, distribution, and advertisements of tobacco products and for other purposes. So beyond just health, what's the fundamental policy driving this whole intricate thing?
Well, right from Section 2, the foundation is this idea of a balanced policy. It's stated very clearly. It's not just about protecting people from hazardous products or promoting health consciousness. Crucially, it also explicitly says the state aims to safeguard the interests of, everyone involved in the tobacco industry, the workers, the farmers, other stakeholders. This dual commitment, this balance, it's central to understanding everything else in the act. It's a recognition, really, that you can't just ban an entire industry overnight without causing, potentially devastating social and economic problems.
Right, that makes sense. So with that kind of overarching balanced policy in mind, what were the specific actionable goals the act actually set out to achieve?
Okay, Section 3 lays out 7 clear purposes. First, pretty straightforward, promote a healthful environment. Second, make sure the public is fully informed about the health risks, transparency. Third, and this is a big one we'll get into, regulating and then subsequently banning tobacco ads and sponsorships. That's key. Fourth, standardizing the labeling on products. Fifth, protecting young people by prohibiting sales to minors, a major focus. Sixth, actively helping Filipino tobacco farmers transition to alternative crops to prevent economic dislocation. That's the support side. And seventh, establishing the Interagency Committee on Tobacco, the IAC Tobacco, to oversee the whole implementation.
Okay, before we get into all those rules and regulations, understanding the language, the actual definitions used, seems really important for grasping how far this law reaches. What are some of the most crucial terms we need to get our heads around?
Yeah, the definitions in Section 4 are incredibly meticulous.
Yeah.
They really aim to close any potential loopholes. Take advertisement and advertising. It's not just TV commercials. It covers basically any message promoting tobacco, visual or audible, brand names, logos, across all mass media.
All mass media, so that includes
Everything. Print, broadcast, and importantly, even back then, electronic media like the internet. They were thinking ahead. Minor is crystal clear. Anyone under 18. Super important for all the youth protection rules. Point of sale is just anywhere you could buy tobacco. Simple enough. But then you have public conveyances and public places. They list specific examples: elevators, hospitals, schools, airports, restaurants. It shows just how wide the smoking ban was intended to be.
And even smoking itself has a broad definition.
They're very broad. Just carrying a lighted tobacco product counts, whether you're actually puffing on it or not. And they carefully define sponsorship and promotion separately too, tackling things like logos on merchandise or paying for product placement. The breadth is really quite striking, shows the comprehensive intent.
Okay, so let's talk about one of the most immediate impacts people felt, the smoking ban. Where did this act draw a really firm line? Where was smoking absolutely forbidden?
Section 5 made it absolutely clear. No smoking, period, in places focused on youth play schools, colleges, youth hostels, you name it. Also, elevators and stairwells. Makes sense. Places with fire hazards like gas stations or chemical storage areas, and critically, within the buildings and grounds of hospitals and medical facilities. Complete ban there. Public transport and terminals, too, like airports and bus stations, unless they had very specific, separate, enclosed smoking areas. Oh, and food preparation areas. Definitely no smoking there.
Okay, so those were the absolute no-go zones. What about other places people frequent, like workplaces or just general public areas? Was it a complete ban there, too, or different rules?
Not a total ban everywhere else, no.
Yeah.
But very strict regulations under Section 6. In enclosed public places or private workplaces where non-smokers might be exposed, the owners or managers had to set up designated smoking and non-smoking areas, clearly separated.
And these designated areas had specific requirements.
Yes, very specific. The smoking areas needed a clear smoking area sign. And crucially, that sign also had to include a health warning about the dangers of tobacco smoke. And the non-smoking areas had to be just as clearly marked, non-smoking area or no smoking. Hmm. The goal was clear separation and reducing that secondhand smoke exposure as much as possible indoors.
That makes sense. And this leads us naturally to protecting young people, which, as you said, was a major focus. Beyond limiting where people smoke, how did the Act specifically try to keep tobacco away from minors?
Oh, this was a huge part of it. Sections 7 through 12 really focus on access restrictions. For instance, vending machine sales were basically outlawed unless they had some kind of reliable age verification. Self-service displays, too, retailers had to make sure minors couldn't just grab packs. But the core rule, Section 9, made it unlawful for retailers to sell or distribute tobacco to minors, period. And unlawful for anyone to buy tobacco from a minor or for a minor themselves to sell, buy, or even smoke tobacco products.
Now, here's something that always comes up with age restrictions. What about the classic defense, oh, I didn't know they were underage? Did the Act allow for that?
Absolutely not. The Act is incredibly strict on this. Section 9 explicitly states it is not a defense for the seller to say they didn't know the buyer's age or to know the tobacco was for a minor. The burden of proof, the responsibility, is entirely on the seller to check.
Wow, so no wiggle room there.
None. And if a minor is caught buying, selling, or smoking, they fall under the Child and Youth Welfare Code, which has its own procedures. Plus, Section 10 banned tobacco sales within 100 meters of schools, playgrounds, or anywhere else kids frequently gather, creating a buffer zone.
And signs. Were stores required to post warnings?
Yes, absolutely. Section 11 mandated clear signage at the point of sale. Something like sale, distribution to, or purchase by minors of tobacco products is unlawful. Big, clear warning. And finally, Section 12 hammered it home. Retailers must verify age using a valid photo ID if they have any doubt about the buyer's age. No guessing allowed.
Okay, let's shift gears to, well, what feels like the other really big piece, advertising and promotion. This act seemed to have a clear plan to really shrink and eventually eliminate tobacco marketing. First off, those warnings we started seeing everywhere, on packs, in ads. What were the rules there? They were quite specific, weren't they?
Incredibly specific. The goal was to make them unavoidable, really integrated into the product and its marketing. Section 13 dealt with packages. It mandated 4 rotating health warnings, things like smoking is dangerous to your health, cigarettes are addictive. And these warnings had to take up a significant chunk of the package space. It evolves over time, but by July 2006, it was 30% of the bottom front panel. Big.
And specific design rules, too.
Oh, yes. Specific colors, text size, borders, everything to make sure they stood out and couldn't be easily ignored or blended into the design. Plus, every pack also had to have "No sale to minors" printed clearly on a side panel. And importantly, no other health warnings were allowed to keep the message consistent and clear.
Okay, that's packages. What about warnings in actual advertisements?
Similar principle make it prominent. Section 14 required a general health warning in all ads. For print and outdoor ads, the warning had to occupy, I think, 15% of the bottom area, clearly framed. For TV and cinema, it was even more specific. The warning had to be shown visually and voiced over during the last 5 seconds of the ad.
The last 5 seconds?
Yes, occupying at least half the screen, specific contrasting colors, no other images allowed in the frame during the warning, very disruptive of the ad's flow intentionally, and on radio, a clear voiceover warning in the last 5 seconds as well. The idea was saturation warnings everywhere tobacco was mentioned.
So, beyond just adding warnings, were there rules about the content of the ads themselves? What couldn't they show? Who couldn't they target?
Yes. Section 15 put tight restrictions on the content. Ads absolutely could not be aimed at or appeal to minors. That meant no cartoon characters, no features that might seem comical or targeted at kids, and definitely no celebrities endorsing tobacco products. That was out.
What about showing people actually smoking?
Also forbidden. No actual use, puffing, or even lighting up a cigarette could be shown in ads. And any people depicted in the ads had to be, or at least appear to be, over 25 years old. Again, steering clear of youth appeal. The focus was clearly on deglamorizing it, especially for young people.
And then the act got even more specific, didn't it? It laid out rules for different types of media print, TV, billboards.
It really did. Incredibly detailed. Section 16, Print media ads were only allowed in publications where at least 75% of readers were adults and youth readership was below 10% of all youth, basically adult-only publications. And no ads on covers, ever. Section 17, outdoor ads, no billboards or murals within 100 meters of schools, playgrounds, etc. They had size limits too, could be massive. No ads on buses, trains, taxis, or in their stations, except right at the point of sale. Section 18, banned entirely if minors were allowed admission to the cinema or the specific film. Section 19, TV and radio. No tobacco ads broadcast between 7 a.m. and 7 p.m. Primetime viewing hours were restricted. And sections 20 and 21 covered things like video cassettes, discs, and importantly, the internet. Electronic ads were only okay if the site or medium was strictly age-gated, restricted to 18 and over.
You mentioned earlier the Act talks about a subsequent ban on advertising. This sounds like it wasn't just regulation, but a move towards total prohibition. When did those bans actually happen?
Exactly. It was a phased elimination. Section 22 lays out the timeline clearly. Starting January 1, 2007, all tobacco advertising on television, cable TV, and radio was completely prohibited. Gone.
Wow, that quickly.
Yes. And then 6 months later, July 1, 2007, all cinema and outdoor advertising was prohibited too. The only place you could potentially see an ad after that date was literally inside the store where tobacco was sold, at the point of sale. It was a comprehensive, scheduled removal from public view.
That is a really strong statement, essentially wiping tobacco ads off the map over a fairly short period. What about promotions and sponsorships? Did the Act treat those similarly?
It did, applying the same kind of detailed restriction followed by an eventual ban. Section 23 covered promotions. They had to be directed only to adults, 18-plus sales, with proof of age needed. Any promotional materials had to follow the advertising rules and state the age requirement. Any stalls or booths handing out promotional items were limited to point-of-sale locations or adult-only venues. Even telephone promotions needed recorded health warnings.
What about seeing brands in movies or games?
Section 23 specifically banned using tobacco products or ads as props in TV shows, films, or video games meant for general public viewing, trying to stop that subtle normalization. There were even rules for branded merchandise. Things like lighters or ashtrays needed a health warning if the logo was big. And crucially, no merchandise like t-shirts, caps, backpacks, stuff like that could be distributed if the brand logo was visible when worn or used. And clothing had to be adult sizes only.
So no walking billboards.
Pretty much. And definitely no logos on things kids might use: sports gear, toys, food items. Manufacturers were also responsible for preventing misuse by third parties. Even shopping bags couldn't have tobacco ads.
What about naming rights? Could a cigarette brand sponsor a sports team or name a stadium?
Section 24 explicitly prohibited that. No payments to leagues or teams for using tobacco brand names. No naming stadiums or arenas after tobacco brands. And Section 25 restricted sponsorships starting in mid-2006. Basically, no sponsorship if the event or team carried the brand name, unless everyone attending or participating was 18+ resent. The event wasn't aimed at minors, and any exposure followed the media rules. Very tight.
And then, just like advertising, did the final hammer drop on sponsorships too? Was there a date for a total ban?
Yes, following that same pattern. Section 26 brought in the full ban on sponsorships. Starting July 1st, 2008, cigarette and tobacco companies were completely prohibited from sponsoring any sports, concert, cultural, or art event, or individuals like athletes or artists. That is, if the sponsorship involved any advertising or promotion of their products, company names, or logos.
Any exceptions at all?
Just one tiny one. A simple listing of the company name and a general roster of sponsors was okay, but no branding, no promotion tied to the sponsorship. It effectively cut the link between tobacco and these popular events. And the Act also prevented registration of new tobacco brand names as company names after it took effect.
It's just fascinating, the level of detail and that clear roadmap towards eliminating marketing. Just one last thing on the sales side. What about sampling? Free giveaways?
Section 27 handled that briefly but clearly. Sampling was prohibited to anyone under 18. No freebies for minors. Full stop.
This is such a huge, complex piece of legislation. It makes you wonder, who was actually in charge of making sure all of this happened? Who enforced it?
That responsibility fell to a new body created by the Act itself. The Interagency Committee on Tobacco, or IAC Tobacco, as mentioned in Section 29. This committee was given the exclusive power and function to administer and implement the Act.
And who was on this committee? Was it just health officials?
No, and this goes back to that balanced policy idea.
Yeah.
It was chaired by the Secretary of Trade and Industry, with the Secretary of Health as the vice chair. But the members were diverse. Secretaries from Agriculture, Justice, Finance, Environment, Science and Tech, Education, the head of the National Tobacco Administration, and importantly, one representative from the tobacco industry itself, and one from a non-governmental organization working on public health, a real multi-sectoral body.
Trying to get all viewpoints represented in the implementation.
Exactly. Aiming for that holistic view, considering all the angles laid out in the Act's policy.
Okay, and does this whole act apply to absolutely everything, or are there exceptions, like for tobacco made just for export?
Good question. Section 30 clarifies that. The Act applies to all tobacco products put into commerce in the Philippines. Products made purely for export are generally exempt from the packaging and labeling rules, but their containers must be clearly marked export only. And here's the catch. If a product marked export only is found being sold domestically, it's subject to immediate confiscation and destruction. So it prevents that being used as a loophole.
Right, keeps the domestic market rules strict. So we have all these rules, the committee overseeing them. What happens if someone breaks the rules? Let's talk penalties. Section 32. Right.
Yes, Section 32 outlines the penalties, and they are definitely tiered, getting progressively tougher, especially for repeat offenses.
How does it break down, like for violating the smoking ban?
For violating the smoking ban in public places or the rules on designated areas, Sections 5 and 6, it starts with fines. PHP 500 to 1,000 for a first offense, then PHP 1,000 to 5,000 for the second, and for the third offense, it jumps to PHP 5,000 to 10,000, plus potential cancellation or revocation of the business permit.
Okay, steeper for repeat offenders. What about violations involving minors selling to them the signage access rules?
Those penalties, for Section 711, are more serious right away. First offense, a fine of at least PHP 5,000 or imprisonment up to 30 days. For subsequent offenses, it's both the fine and imprisonment, plus the business license can be revoked. And the law specifically states that owners, presidents, managers of businesses are held liable. If a minor is caught, again, they fall under the Child and Youth Welfare Code.
And the really big penalties must be for the advertising and sponsorship violations.
Oh, yes. Violating Sections 13 through 27, the advertising, promotion, sponsorship rules, that's where it gets very serious.
Yep.
First offense, a fine up to PHP 400,000 or imprisonment up to 1 year or potentially both. Second offense, fine up to PHP 200,000 or up to 2 years imprisonment or both. Third offense, fine up to PHP 400,000 or up to 3 years imprisonment or both, plus revocation of the business permit.
That's significant jail time and fines.
Absolutely. And again, owners and managers are liable. And there's the kicker for foreigners. If found guilty, they face summary deportation after serving their sentence and are barred from ever re-entering the Philippines, a very strong deterrent.
Wow, okay, that covers the stick. But you mentioned the balanced policy also involved support, the carrot, if you will. What kind of support systems did the Act actually create, especially for those like farmers affected by the regulations?
Right. Section 33 is all about these supportive programs and projects showing the other side of the coin. For up to 5 years, there was a Tobacco Growers Assistance Program. This offered financial support, like grants, to farmers who actually stopped growing tobacco, helping them transition. There were specific criteria to make sure it reached those genuinely displaced. There was also support for tobacco growers' cooperatives, promoting alternative farming systems and other ways to make a living.
So direct help for farmers. What else?
A lot more, actually. A national smoking cessation program, run with the IAC Tobacco's approval. A research and development program looking into risk reduction, maybe alternative uses for tobacco plants, led by the National Tobacco Administration and the Department of Science and Technology. A national tobacco-free public education program, which interestingly included scholarships for dependents of tobacco growers, helping them access higher education or vocational training.
Scholarships too. That's quite comprehensive.
It really was. There was also an assistance program specifically for displaced cigarette factory workers, handled by the Department of Labor. The IAC Tobacco could also give grants to medical institutions for treating smoking-related illnesses, and the Department of Health was tasked with setting up smoking withdrawal clinics. And treatment costs for minors in these clinics could even be reimbursed through the National Health Insurance, PhilHealth. It tried to cover many bases.
And connecting to that support, what about general public awareness and education on the dangers?
That was also mandated. Section 34 required the Department of Health, Department of Education, and the Philippine Information Agency to run continuous public information programs about the harmful effects of smoking, keeping the message out there. And Section 35 required instruction on the hazardous effects of smoking health, environmental, economic impacts to be integrated into the curriculum for all elementary and high schools, public and private, educating kids directly in school.
So a massive effort on rules, enforcement, support, and education. Lastly, how did the act make sure it actually stayed on track? Was there any kind of oversight built in to monitor how it was all working?
Yes, there was. Section 36 established a Congressional Oversight Committee on Tobacco. Its job was specifically to monitor and review how the act was being implemented, at least for the first 3 years. Legislative oversight.
And the rules for implementation, did they have a deadline?
They did. Section 37 gave the IAC Tobacco 6 months to come up with a detailed setter, implementing rules and regulations, IRR. But crucially, it also said that if for some reason those rules weren't issued within that time frame, the specific provisions of the act itself would become immediately effective.
Ah, so no getting stuck in bureaucratic limbo.
Exactly. It ensured the law would move forward regardless. The act also covered appropriations, how it would be funded, and included standard legal clauses, like a repealing clause to ensure consistency with other laws, a separability clause, and an effectivity clause stating it took effect 15 days after publication. Standard but important legal elements.
So wrapping this all up, what does this incredibly detailed deep dive mean for you, our listener? We've really gone through the Tobacco Regulation Act of 2003, RA 9211, and it truly shows a government trying to perform this balancing act, protecting public health from a known hazardous product, while at the same time really consciously considering the economic impact on a major industry and its workforce.
Yeah, and looking at the bigger picture, it just highlights the incredible level of detail, the planning, the foresight needed to try and drive such big social and economic changes through law. It's so much more than just saying don't smoke here or don't advertise. It's a phased, comprehensive strategy that tries, at least on paper, to account for everyone involved. The detail is just quite something.
It really is fascinating how one law can reach into so many corners of daily life, where you can smoke, sure, but also the ads you see or don't see anymore. The support for farmers switching crops, help for factory workers, even what kids are taught in health class. It demonstrates just how interconnected public health policy can be with economics, with education, with, well, everything.
And maybe this leaves us with a question to think about. When you see this level of detail, this phased approach, these support systems all built into one act, how effective can such comprehensive long-term legislation really be? Can it fundamentally shift society's habits? Can it really change how an industry operates over decades? And maybe what other complex public issues could benefit from this kind of deeply integrated, forward-looking legislative approach instead of just simple fixes?
Lots to think about there. We hope this deep dive gave you that shortcut to being truly informed about the Tobacco Regulation Act of 2003. Maybe it sparked some new questions for you too. Until next time, keep digging into what matters.